All right, welcome everyone to another meeting of the Senate Judiciary Committee. We're going to go ahead and get started now. We do have 3 bills to consider, so we need to get going. Paging Senator Crum. Pierre, if you would like to do a roll call.
Senator Crago,
Excused.
Senator Crum,
Here.
Senator Hicks,
Oh, excused.
Senator Kolb,
Present.
Chairman Olson.
Here.
Mr. Chairman, you have a quorum.
See, you got to do the roll call and your dad wasn't even here for it. What's up? We're going to have to redo it when he comes back. Okay, we have Senate File 22, ground for termination of parental rights guardianship. Senator Schuler. Welcome to Judiciary.
Thank you, Mr. Chairman. I kind of missed being on Judiciary. I kind of enjoyed it, and I guess I got kicked off. I don't know if I didn't do a very good job or just what, but anyway. Senate File 22 is actually kind of a result of some of the discussions that we had during the interim with the increase in grandparents and aunts and uncles and family members that were raising their kids in the state of Wyoming instead of the parents. And just to give you a few data sheets, I'm sure you like data. Right now in Wyoming, there are 9,353 children living in homes where a relative is the head of the household. 3,754 grandparents that are responsible for their grandchildren. And for every one child raised by a family member in foster care, there are 10 being raised by family members outside of foster care. So we're seeing a huge increase, not just in our state, but actually throughout the country. And just to let you know that kids that are in foster care in the United States, they're about 5 times more likely to have anxiety and depression, behavioral problems than children not in foster care. So children do thrive when they're with their family members, their relatives. You know, we'd like to have them with their parents, but sometimes it just isn't feasible. So after hearing some of the concerns during Judiciary from mostly grandparents, but a few others, about the fact that they were raising their grandchildren, and you know, they were hoping that the parents, one or both, would come around, and of course maybe one was in jail, maybe one was in treatment programs and so on and so forth. But the bottom line is the kids were being bounced around, like pinballs. And if you know anything about adverse child experiences, I think it's about 1 in 36 if they have no ACEs, which is the ACE, the adverse childhood experiences. If you compare those to the welfare system to the general population, it's 36 to 51%, big difference. So anyway, Senate File 22, we brought this bill, and it's a bill that provides a guardianship with the relative and a finding of unfitness that could be a ground for the termination of parental rights. And again, there's already 9 grounds in statute which pertain to grounds for termination, and some of those, I'll just briefly read some of those. If the child's been left in the care of another person without provision for the child's support, without communication for at least a year, that's one ground. If they've been abandoned with no means of identification for 3 months, that's another. If the child's been abused or neglected by the parent and efforts to have been unsuccessful in rehabilitating the family, I can't talk today, another one. Child's been in foster care under the responsibility of the state for 15 of the last 22 months, it's another one. A parent is incarcerated due to the conviction of a felony or showing that the parent's unfit. The child's abandoned at less than 1 year of age, has been abandoned for at least 6 months. The child was relinquished to a safe haven provider, and neither parent has sought the return of the child within 3 months. The parent is convicted of murder or homicide or the other parent, and the parent committed, this is the last one, committed sexual assault, and the child was conceived as a result of sexual assault. So this is just adding another one. This is adding 10. It just basically says that the parent-child legal relationship may be terminated if any one of those rules is established by clear and convincing evidence. And that's, I think, the important thing about these grounds, that there has to be clear and convincing evidence. Wyoming rules of civil procedure do apply to the proceedings for termination of parental rights, and the court has to find a statutory basis for termination by clear and convincing evidence. So this would say basically that the child It just adds 10. The child has been appointed a guardian who is a relative of the child. The child has been under the guardian's care for more than 24 months, and the parent is unfit to have the custody and control of the child. And the bottom line is, the bill's fairly simple. Honestly, we heard that South Dakota had a bill that they passed in 2023, and we used that bill to kind of use to help us, I guess, model after them. And there's, I think, other states that are looking at this issue with grandparents and family members. The bottom line is we want to reunify with the parents, and sometimes it just can't happen. We heard parents, you may hear some testimony today of grandparents that, have had their grandkids for maybe 3 years or more. Mom's in and out of treatment, or dad is, or, there's just all kinds of things that can happen. And it's really starting to affect the kids, and that's where we're seeing the ACEs situations. And these ACEs, if you do any of the study on those, they follow those kids around their whole life. Sometimes they have emotional issues, sometimes, they're very depressed, and sometimes they're suicidal. And, you look back at their lives where they've been bounced around, and you can't blame them for feeling the issues that they have. So this is just a bottom line where, times are different now than they used to be. We've got to protect the rights of our children to have a safe and healthy environment so that they can thrive and not just survive. And so I look at this bill as just one more tool in the toolbox. We've got too many kids that are already having issues and not being safe and not being healthy. And we have folks out there that are relatives that can provide love and care that they need. So with that, I'm open to questions. Be happy to answer them.
Senator Kolb?
Thank you, Mr. Chairman. Well, good afternoon, Senator Schuler. I guess a couple questions about why 24 months? What was the background on how you came up with 24 months? Just like to know more about that. And then a larger question is, in the future, if a parent, say, reformed themselves and became capable in the future, is there any redemption for said parent in the future once this has happened, if this may comes to be it did come to pass? Your thoughts on that? Thank you, Chairman.
Senator Schuler?
Mr. Chairman and Senator Kolb, yeah, we had discussions. I actually went back home after some of the judiciary meetings that we had, and feeling kind of sad about some of these things that were going on in our society. And so I kind of asked around, because I knew that there were parents that were just absent even before I finished teaching, retiring, that there were parents. We had a lot of grandparents coming in for parent-teacher conferences, aunts and uncles, cousins. So you could kind of see that this was happening. Didn't realize it was happening quite as often. I started looking at the statistics, for just my county. We're not, of course, as high as obviously Fremont County and some of the others that are out there, but I think right now there's 1 in 112 in Uintah County, their grandparents caring for their kids. There's 1 in 54 in Fremont County. Goshen County is 1 in 77, Sublette 1 in 78. So just a lot of counties seeing a lot of increase. And in talking with some of these grandparents, they've tried everything with their kids. And, maybe it was a single mom, who knows what it was, if it was both parents or one parent. But 24 months seemed like the average when we started looking around at some other states, what they're doing. I don't know if it's the magic wand or not, but I would say if a little kid has been in a family with, grandpa and grandma for 3 years, 4 years, I mean, enough's enough. So to me, 2 years seemed like a reasonable amount. And I don't remember if I wrote down the states that have that, but I think I looked at some other states that do have that. And I mentioned a little bit ago about the Senate, about South Dakota, the legislature. That's the next bill, so forget about that. Yeah, I'm coalescing the two, sorry. It's been a crazy day already. So anyway, that's my answer for those questions. Thank you.
Senator Kolb, to answer the second half of your question, there is no redemption in state law. So once your parental rights have been terminated, it's done and over. You don't get to come back and get a second bite at the apple. Senator Kolb?
Yeah, thank you, Mr. Chairman. Are courts then unable to take this action now? I mean, if the judge sees the situation, are they prohibited from considering this type of circumstance for termination of rights currently? Thank you, Mr. Chairman.
Senator Schuler.
Yeah, Mr. Chairman, Senator Kolb, my understanding, those 9 grounds that are in statute, which this will be adding the 10th, that the termination has to go through that process, the Wyoming Rules of Civil Procedure to start those proceedings for termination. And without those, no, it's nothing in place to take care of it as of right now for this particular situation.
Senator Schuler, to me, the safety valve or the sideboard, if you will, on what you're trying to do here is the unfitness finding that has to take place. So I don't know what magic there is to 24 months. I know for a child outside of the parent's care in the current scheme of statutes, there's it's like 15 of the last consecutive 22 months or something like that. And I don't know if there's any magic to any of that, but to me, I have comfort in knowing that there still has to be a finding of unfitness, which I think that's a pretty high bar, actually. Even though it's clear and convincing evidence, to prove a parent unfit, at least in my experience in Wyoming, that's a pretty high bar. So, good safety valve.
Thank you, Chairman.
Wouldn't you agree?
Yes, I would agree. And like I said, I know our DFS director is here also. She may have a little more information to add to this as well. But like I said, I just, my heart was breaking this summer when I started working on this and talking to people and visiting with grandparents. And so it's happening more than we'd like, that's for sure.
And just in the construct of the way this statute is written, I kind of see a couple of ways to approach this. Right now, it's worded as more than 24 months, which means 24 months would not be sufficient. Is that the intent, or is the intent to be at least 24 months?
Mr. Chairman, I would be open for that amendment. I think that would be a friendly amendment. I think at least 24 months, I think would work just fine.
And then are you okay with it being 24 consecutive months? Because that would be consistent with the current statute.
Yes, Mr. Chairman, I believe that's how I would prefer to have it.
Okay, very good. Any other questions for Senator Schuler? Senator Crum.
Yes, Mr. Chairman, yes, back on the parental rights, if they rehabilitated themselves, there's nothing to keep the grandparents, or whoever the new guardian is, from allowing the birth parents to come visit if they're fit to do so. Would that be correct?
Senator Schuler.
Mr. Chairman, Senator Crum, that's absolutely correct. And I think that's the hope, is that eventually there might be some reunification, but it's just not worth it for these kids to never know. You know, is mom going to be clean? Is dad going to be out of jail? I just think that the grandparents that have helped to raise these kids, they're amazing people, I will tell you that. And I think their hope is that eventually there could be some family ties in there somehow, somewhere.
Senator Kolb.
Yeah, thank you, Mr. Chairman. Senator Schuler, but they don't have to. They don't have to allow any visitation. I mean, clearly they don't have any more parental rights, so that's finished. Just to say, my reason for even asking that question before about restating your rights was not because I didn't know the answer. It was because this is a very final thing, and God bless the grandparents that are taking this responsibility on. But this is finality, and it's a very, very serious thing, and that's why I'm concerned about the question back and forth about what you thought about it. Thank you, Mr. Chairman.
Senator Schuler.
Yeah, Mr. Chairman, Senator Kolb, you're absolutely right. Once those grounds, you hit one of those 9, hopefully 10 grounds for termination, yeah, it's over. So again, it's not in the mix. There's no gray area after that.
All right, thank you, Senator. We will move into public comment. Does the Department of Family Services wish to testify on this bill?
Thank you, Mr. Chairman. My name's Corin Schmidt. I'm the director of the Wyoming Department of Family Services. Termination of parental rights happens outside of the child welfare system. I was just here in case there were questions or anything about how these intersect, but the TPR statutes, the termination of parental rights statutes, sit outside of what we do in our child welfare system. More than anything to say that this particular piece of legislation really doesn't have an impact on us.
Director Schmidt, under this section of termination of parental rights statutes, can both the state and a private individual bring an action? Not at the same time, obviously, but both are permitted parties to bring an action?
Mr. Chairman, the way that we're reading it, if a child's in a guardianship, they're probably not going to be in our system anymore. That's one of our permanency things. So if there's guardianship, then most typically by then we'll have stepped out of the case.
So if a child is placed in the care of a relative, and they're only there for a couple of months, and then that relative decides to file for a guardianship and the court agrees and puts that guardianship in place, you exit at that point, even if it's only been a couple of months?
If there's been an abuse and neglect petition filed under Title 14, then we have an obligation for reasonable efforts with that family, with that.
For reunification.
For reunification. And that's where the 15 of 22 then comes in for termination of parental rights. If a child's been in custody for the last 15 of the last 22 months, then that's grounds, that's one of the 9 elements that Senator Schuler spoke to for termination of parental rights.
Right, I understand that, but if it's on, what I'm trying to ask is, if your position is that that when a guardianship is ordered, no matter how long the child has been in the system, your understanding is you would exit, the Department of Family Services would just exit the action.
So Mr. Chairman, in a typical case, we will be present working with the court on the determination of that guardianship. So if there's a case in juvenile court and a family goes outside of the juvenile court judge to ask for guardianship, I know there's attorneys in the room that could probably help with that.
It would be really unusual.
It would be very unusual, yes.
Yeah, I guess I'm thinking of a really unusual pattern, but.
Yeah.
Okay. All right, any other questions for Director Schmidt? All right, thank you. All right, we'll open it up to general public comment. Anyone wishing to testify on this bill? Yes, please come forward, both of you. Welcome, go ahead and state your name and then let us know what you want us to hear.
Good afternoon, Chairman and members of the committee. My name is Pat Hartley, and I come to you this afternoon as a mother and a grandmother, and I appreciate Chairman Olson allowing me to share my story with the committee. I will try to be quick, but I am speaking not only for myself, but for many of the grandparents, aunts, uncles, and other relatives who are raising children that they didn't anticipate having. My husband and I are grandparents raising our grandchild. Both his mother and father struggled with addiction, were in and out of trouble with law enforcement, and had no capacity to raise our grandchild. When they had him, my grandchild was exposed to drugs, neglect, left in unsafe environments, and much more. My husband and I struggled to figure out how to help. We called DFS, law enforcement, tried everything we could do to help our older child as well as our grandson. We sent our child to treatment multiple times to no positive effect. We did all the parental things. We took him to daycare, we took him to school, we took all of his medical needs, bought all of his clothes, celebrated his birthdays. In every way, he was our child. We finally obtained legal guardianship when he was 3 years old, but were not finally able to adopt until he was 7. My grandfather's mother and father struggled with addiction and criminal activity the entire time. They would seemingly get clean for a short period of time, only to start the cycle again, inevitably ending up in trouble. They would disappear off the radar for many months, sometimes more than a year, then pop back in and then disappear again. It was a cycle that never seemed to end, elongating the legal process, and every time it turned my grandson's world upside down, and often resulted in him losing all progress he had made, being traumatized again, and losing his sense of security. One thing I would mention is that our experience with DFS and law enforcement, they did everything they could to protect our grandchild. Every time we called in a report, the parents would run to a different county or state for a short period of time, making it impossible for anyone to keep tabs on them. I have come to learn that addicts are very adept at hiding and covering things up, way more than any of us could ever anticipate. I used to think we were unique as grandparents. I have come to learn over the years that we are not, and that the number of children being raised by grandparents like my husband and I, or aunts and uncles, etc., is apparently a growing trend, mostly caused by addiction and the accompanying abuse, neglect, and criminal issues that frequently accompany this problem. Someone told me that there were more than 7,400 grandparents alone, not counting aunts and uncles, in Wyoming that are raising their grandchildren. We were lucky, well, maybe lucky is not the right word, fortunate to meet several families at my grandson's school here in Casper in similar situations. It is hard enough watching your child struggle, but it's the worst thing in the world to watch your grandchild struggle. My grandson had to struggle with abuse, neglect, illegal drug exposure, both pre-birth and after birth, being constantly in danger and never having security. My husband and I never hesitated, knowing that the best thing was for us to care for him to the best of our abilities. We still hope and pray every day that his mother would get better, but we knew that our grandson needs a stable home. The trauma continues to affect him to this day, years after his adoption was finalized at the age of 7. He is still receiving therapy and support, but he didn't really make any forward progress until we finally adopted him and he realized he was on stable ground. What I can share with the community today is he is doing well, and that we hope that by adopting him, we have put him on a different path and broke the cycle of addiction. There are many stories like ours. Many relatives, mostly grandparents, they have had legal guardianships over children for more than a year, many for multiple years like we did, and they can't move forward or are stuck in this endless cycle. One I know has been trying to adopt for more than 2 years, and even though one parent is in jail for a felony and the other is deceased, they still can't move forward. Another has had legal guardianship for almost 4 years and has been told there is no way forward by the court because the parents object, even though the parents are not really involved in the child's life and cannot take care of the child. The issue with moving forward from legal guardianship to adoption seems to center on this issue of termination of parental rights. I don't know much about the specifics, but I do know that, like the director said, if a child is in DFS custody, the rights can be terminated in 15 of 22 months. As I understand it, there is no equivalent process for those of us who stepped up and took legal guardianship of a child that is a relative, with no DFS involvement like my husband and I did. We can apply, but there are no guidelines in statute as to time frame or consideration of length of time. In our case, we had to wait until the parents did things so egregious that one fled the state and the other ended up in a state penitentiary under separate criminal charges not related to the child, even though the court would not terminate their rights until we had obtained the permission of the one parent that was here in our prison system. Hence the 7 years it took to finally complete the adoption. The other issue I hear about is different counties handle similar cases wildly differently, some making it easier to adopt, others do not seem to allow it for virtually any reason, especially if either biological parent objects, regardless of the length of time or whether the parent is involved in the child's life. One phone call or present given to the child can start the clock all over again. Excuse me. One thing that no one seems to talk about is that when you have a family member with addiction who is in and out of jail or prison, it doesn't just affect that family member. Addiction is often not only an addiction, it often seems to lead to a life of violence, crime, fraud, and more. It is a living hell for the entire family. Excuse my language, sirs. Multiplied exponentially when children are involved. When a child cannot be raised by their parents, it is horrible. I say that as a parent and as a grandparent that prays every day that my adult child will get better. And I hope that one day my child will be well enough to sustain a relationship with my grandchild. My husband and I have lived in Wyoming now for a very long time, and I hope that we can figure out a way to help Wyoming families take care of Wyoming families. Thank you for letting me share my thoughts and my story, and I'm happy to answer any of your questions.
Thank you, Ms. Hartley, for sharing that with us. We really appreciate you putting that together and letting us know your story. Are there any questions, committee? All right, thank you.
Good afternoon, Mr. Chairman and members of the committee. My name is Colin Hartley, and I am 14 years old and a freshman at Kelly Walsh High School in Casper. I am here today to share a little bit with you about what it's like to be a child in these situations. My biological mother has struggled with drug use problems for a very long time, and because of that, a lot of bad things have happened to me, such as having dental surgery at the age of 4 due to meth mouth. But the good thing that happened, the best thing, is that my grandparents decided to take me in as their own. They tell me I was with them a lot on and off for a few years after I was born, but didn't come to live with them full time until I was about 3 years old. I don't remember a lot from that back then, but I do remember being 5 or 6 when my biological mother would show up sometimes and then disappear again for a while. I don't remember my biological father because he left when I was very young. When I was 6 years old, my grandparents asked if they could adopt me while my biological mother was in prison. My biological father had long left to go to Michigan. On some level, it didn't really occur to me that my grandparents weren't really my parents. It took a really long time, but they were finally able to adopt me in October 2017. As long as I can remember, my grandparents have been my parents, my house has been my house, we have a dog, I go to school and participate in the ROTC program. We like to go on trips around Wyoming. I get to see lots of my cousins, sometimes even too much of my cousins. But while my grandparents have provided me a home, got me counseling, and helped make sure I do well in school, I also have friends and other people in my life that aren't that lucky. I have a friend who lives with his grandmother until his mom randomly shows up and says he has to live with her. Usually in a few months, he is back at his grandma's house, but he has to leave his school, his friends, and everything every time it happens. And it's been going on for a long time. Just at my school, there are quite a few kids like me who live with their grandparents because their parents have drug problems or other bad habits. I feel bad for them because it's a hard situation to live with. I hope that the committee will vote for this bill to help some other kids like me.
Thank you, Mr. Hartley. We appreciate you sharing your story with us. Any questions, committee? All right, again, thank you.
Thank you.
Any other testimony in the room? All right, if not, then we'll go to our online testimony. Carson, looks like you're here.
Yes, Mr. Chairman.
All right, go ahead and introduce yourself and then let us know what you want us to hear.
Mr. Chairman and members of the committee, my name is Carson Lauji, and I'm a second-year law student at the University of Wyoming. I practice family law through the UW Family and Child Legal Advocacy Clinic. I've had the opportunity to represent clients in termination of parental rights, or TPR, cases on both sides as a petitioner and as a respondent. My testimony today is against Senate File 22, which would include a new ground for TPR to be when a child is in a guardianship with a relative and that the natural parent is found unfit. Termination of parental rights, or TPR, is a unique area of the law. it's often referred to as the civil death penalty because there is not a more severe remedy you could ask for in a civil court than to terminate someone's parental rights. The Supreme Court has recognized a fundamental and constitutional right to parent, and TPR severs that legal relationship between a parent and a child. The goal for TPR and termination of parental rights cases is to provide for legal permanency for children. It's to prevent children from languishing in foster care and to free them up for more permanent family relationships like adoption. And many times, this is to free them up for adoption with the relative foster parents that they currently live with. Guardianship is a way to provide legal permanency for children without unnecessarily severing the legal relationship between children and their natural parents. Changing a guardianship from a TPR alternative to a ground for TPR would create a chilling effect on parents who would have otherwise placed their children in a relative guardianship because they wouldn't want to start the clock ticking on their fundamental parental rights. When I read Senate File 22, I see nothing but good intentions. I see the legislature trying to provide for more legal security for relative guardians who believe it's in their children's best interest to remain with them and not their natural parents. And there are many cases that I have personally seen where this is totally true. But I've been heavily involved in state-sanctioned TPR actions in the past few months, and I feel obligated to inform the legislature of the current nature of these actions and how we should focus on further developing guardianship laws to protect these relative guardians and not termination of parental rights laws, which causes significant trauma for families. Under Title 14, the Department of Family Services will bring TPR actions against parents when their children have been in foster care under the state of Wyoming for 15 out of the most recent 22 months. State law requires DFS to do that unless, as Title 14 also states, the children are in the care of a relative. Despite this language, the Department of Family Services frequently seeks to terminate parental rights after the 15 out of 22 month deadline has been met. Many of these children that are in state's custody are in the care of a foster parent who is also a relative, a grandmother, an aunt, an uncle. The goal is to establish legal permanency for the children and get out of foster care. The state can make arrangements to place the children in a permanent guardianship, or they can terminate the natural parent's rights to free the children up for adoption. Both options essentially have the same legal effect for children, as the guardian has full rights to the children as a parent would. The difference is the speed and the cost that we can get children out of foster care and into permanent legal family relationships through guardianships. When the state pursues termination under Title 14, if the natural parent is found indigent by the court, which is almost always the case, then the Department of Family Services is required to pay the reasonable attorney fees and expenses of the parent's defense. This takes months of litigation and thousands of dollars. This is the money that they spend on food and daycare and clothing support, but they have to pay for the natural parent's legal defenses, depositions, expert witnesses. It's costly and time consuming. We need to look at new ways to use guardianships as an alternative to TPR so that kids can get out of foster care, have legal permanency, and not be forced to endure the trauma that comes with TPR actions. Now, quickly, before I finish, I want to address the safety net of unfitness. Statutes written like this, including Ground 5, where it says that children who have been in the custody and responsibility of the state of Wyoming for 15 out of 22 months and are found unfit, or in the guardianship of a relative and are found unfit, it's written as though it's the high bar to prove unfitness, and that we'll be able to it will be hard because we'll have to use clear and convincing evidence to terminate parental rights once we've shown that they're unfit. But current precedent would suggest that the petitioner could easily prove that a parent is unfit simply by explaining that the child has been in state's custody or a guardian's custody for 15 out of 22 months or for 22 months. This reduces the ground to a simple mathematical equation. I'm referring to Chief Justice Fox and Justice Gray's concurring opinion in a recent case, In Re BAD. Guardianship is the solution to these cases. It's not a ground for termination. As it stands, it's relatively easy and vague to terminate a guardianship should a natural parent want to. All Wyoming statute requires is showing that the guardianship is no longer necessary. If we refocused our efforts to further developing guardianship laws to take a step away from TPR, we can save thousands of dollars, move kids out of foster care and into permanency without the trauma of severing their legal ties to their parents. When a children's parents' rights are terminated, they suffer from ambiguous loss. It's traumatic. It's a significant ACE for children. And this ACE can be mitigated through a simple permanent guardianship. And that's why I urge the committee to reconsider Senate File 22 and consider amending and looking at guardianship laws so we can truly protect children and provide security for these good Wyoming relative guardians who are looking for better protection under the law.
Any questions, committee? All right, thank you for your testimony. We appreciate it. With that, I will close public testimony. Committee, what is your pleasure?
Move the bill.
Moved by Senator Crago. Amendments to this bill? I would like to, on line 7, page 2, strike more than and insert at least. And then between 24 and months, insert consecutive. And I'll make that a motion. Discussion on that motion? All those in favor signify by saying aye.
Aye.
Any opposed? Okay, and then I think also, just to make this consistent with the statutory language that we have already in statute for one of the grounds, I would on line 8, strike the sentence. On the balance of the line on 9, strike, and insert, there has been a finding that the parent is unfit to have custody and control of the child, period. And that more mirrors the existing language in the statute.
Repeat that, please, Mr. Chairman.
Yep, there has been a finding that the parent is unfit to have custody and control of the child, period. The only difference in that is showing versus finding in the, I'm sorry, in the existing language. Senator Crago?
And this might be nitpicky, Mr. Chairman, but when you, the language you're proposing, there has been a finding, is that past tense? Is there, has been a finding in a previous adjudication of some sort, which is not what the current language says? I'm on board with what you're trying to do. I just don't know if we want it to be past tense. Does that make sense?
I understand what, yeah, I don't think that would prohibit it in the existing action. You would have your typical, you'd have an order from the court that has a finding. But I'm open to adjusting the language to make it, I think the existing language is like a present tense. And now that I'm looking at the existing statute, it says a showing that the parent is unfit. So we could just say, and a finding that the parent is unfit to have custody and control of the child. Would that be good?
Perfect.
Okay. Any other discussion? All right, all those in favor signify by saying aye.
Aye.
Any opposed? That amendment carries. Any other amendments to this bill? Any discussion on this bill? Ready to vote? Or Senator Crum, are you wanting to speak on this bill?
Yeah, you know, Mr. Chairman, you know, this is heartbreaking. But, you know, we need to focus on the child and stability in a child's life. And if there's a parent that is just unfit, that makes the child's life unstable, we need to continue, we need to focus on the child and make sure that they have a stable and positive environment to grow up in and put them in a position to succeed. If we don't, we're going to cause the child, the family harm, and as well, we're going to cause society harm because the child's going to be in and out of services for quite a bit of their life. So it's heartbreaking, but I believe this bill's necessary.
Senator Kolb?
Yeah, thank you, Mr. Chairman. Just a statement about, well, thank God for family. Thank God that they're there to pick up the pieces when things go wrong, and they're not replaceable by the government. And I certainly appreciate the families taking care of business within a family. Thank you, Mr. Chairman.
Any other discussion? All right, I do appreciate the comments. Pierre, will you do a roll call vote on Senate File 22?
Senator Craigo,
Aye.
Senator Crum,
Aye.
Senator Hicks,
Excused?
Senator Kolb,
Aye.
Chairman Olson.
Aye.
4 ayes, 1 excused.
All right, there's one down. Senator Craigo, you weren't here when we called roll, and it was a very monumental occasion, as your daughter was the one who did the roll call,
Oh, I'm
and you missed it.
disappointed.
Yeah.
Wanted to call you absent. The chairman saved you.
Yeah.
Absent-minded.
Next, we have Senate File 100, Child Witness Courtroom Procedures. Senator Schuler.
Thank you, Mr. Chairman and committee. Again, I bring you another, I guess you'd call it a child advocacy bill. I guess as a former teacher, I am one of those. And again, this actually came about, again, as a result of some of the discussions that we had during the judiciary, just with, offline and online with various people. And what we found is we're seeing a lot more of issues with sexual abuse, with incest, with human trafficking, with some of our younger folks out there in Wyoming. And so Senate File 100, it allows a child less than 16 in cases of sexual assault or incest to testify outside the presence of the defendant and the jury. Before allowing this remote testimony, here's the key. The court has to hold a hearing, and they decide if testifying in the courtroom would cause the child to suffer more than de minimis emotional distress, and that remote testimony by the child is necessary to protect the welfare of the child. So the court may also exclude the defendant from being physically present in the same room as the child if they're present with substantially, likely to cause substantial, and I keep using that terminology, but substantial emotional distress to the child, and if it would impair the ability of the child to communicate. If the defendant is excluded, the child may testify by the way of a closed-circuit television or other appropriate secure technology, and it shall be televised live in the courtroom simultaneously. The defendant may waive the right to have the defendant's image televised in the room in which the child is testifying. The defendant may communicate by audio system with attorneys outside of the courtroom. And if the district attorney finds that there would be substantial, again, that's the key word, emotional distress, the court may exclude the jury from the room in which the child is testifying. So again, the child's testimony shall be televised at the same time to the courtroom by closed-circuit TV or other real-time audio and video technology. Again, if the defendant is charged with those things that I mentioned, incest, sexual assault, human trafficking, or even a violent felony, and the child is less than 16, they can also provide some of the following accommodations. They can also have a person who would contribute to the well-being of the child, be present and be visible and be close proximity. They can allow sufficient breaks in the proceedings to allow for the comfort of the child. They can also allow to have a certified therapeutic dog present in the room with the child. And then if the prosecutor elects to utilize a videotape deposition, then the child will not or is unable to provide live testimony. The videotape has been taken and is admissible, then the child may not testify in court with the consent of the defendant. So that's kind of the exception. The court may provide for the child to testify under the conditions in WS 711-409 in lieu of a videotape deposition. And I did have a couple of folks that said, what about the confrontational clause of the Sixth Amendment? So I went back and of course did some research on that, because it generally ensures that a defendant has a face-to-face meeting with the witness, but there are exceptions to the exceptional clause. And some of those exceptions are the witnesses might be unavailable, they may have testified against the accused, they may have been cross-examined by the accuser's party, but this is the one I think that kind of pertains to this bill. If there's a government interest in effective law enforcement and it outweighs the benefit of confronting witnesses, particularly in a human trafficking case, for instance, that's an exception. There's a lot of lawsuits, if you go back and look at law, and you guys that are lawyers, I'm gonna apologize ahead of time. I went back and looked at some of the lawsuits that have gone to the Supreme Court. I only found one that I thought really pertained to this, and it was US versus Gaddis. I don't remember the year. but it imposed reasonable limits on cross-examination based on harassment, prejudice, and the witness's safety. And then basically it allows an exception requiring face-to-face permission if there is a child witness under circumstances. I think that child in that case was like 8 years old. Remote testimony, I don't think it infringes on an accuser's confrontational right if it's a necessary matter of public policy, and some other cases have mentioned that. And now I'll mention the South Dakota bill. They passed the same law in 2023. I think it was Senate File 70. And someone asked if that had been litigated, and I checked back, it has not been litigated at this time. So I think this bill will pass constitutional muster. Again, I'm not a lawyer, but I think the bottom line is we want to protect our young victims that have been through such horrific situations with sexual assault, incest, violent felonies, and human trafficking by giving the courts, because again, the courts have the option to allow them to not be re-victimized. They can still say no if they feel like it's a de minimis amount, instead of a substantial amount of emotional distress, they can say no. So I just trust that the courts will use this option rarely, but whenever necessary. And with that, I'd be happy to answer questions.
Senator Schuler, I'm curious if you thought through the may versus shall of this statute. If all of the elements are met for a child to testify either remotely or however, then should it always be the case that the child is allowed to testify that way, or is there still need for discretion from the court? And if so, why?
Mr. Chairman, I wouldn't be opposed to the may in that. You're talking about on page 2?
Yeah, page 2,
Yes.
line 5.
Yes, yeah, I wouldn't be opposed to that, because I still think, the bottom line, it's in their ballpark. And I do trust the court, and so I think may would work fine. I would be
Yeah,
all right
all
with
of
that.
the elements below.
Yeah, they all say shall.
All the way through Romanet 5 would have to be
Yeah.
met. That's quite a showing, I would
Mhm.
think, so. But you lifted this from South Dakota?
Yes,
So that would be the way South Dakota has it structured?
yeah.
And, okay.
We have a few things that are different. We have district attorneys, they mentioned prosecutors, but I mean, for the most part, it's modeled after theirs.
Oh, yeah, I was trying to remember, Senator Crago, you might help me. When we say district attorney, we mean district attorney and county attorney? That's, okay.
Mr. Chairman, in the statutes, district attorney encompasses county attorneys.
Okay. Quite, other questions for Senator Schuler? Yes, Senator Kolb.
Thank you, Mr. Chairman. So Senator Schuler, I mean, obviously, I guess you believe this bill's needed because the courts have failed to protect children. And I don't know, I'm a little confused. I thought the courts had deference to protect children. So I wonder on the next hand, why do we need this bill? If the courts can already do it, have been doing it, unless you can point out something that happened in Wyoming that was, terrible thing. What's the real purpose here? Thank you, Mr. Chairman.
Senator Schuler?
Yeah, Mr. Chairman, Senator Kolb, actually, the courts right now can say, the child has to be there and that's it. This just allows the courts to say, well, if it's a child witness, they may have this accommodation. Beyond that, there's no accommodation that allows it. So a child victim, unless, like I said, there are a couple of, if they wanted to go push the issue and maybe take it to an upper court, there have been cases where there have been exceptions. But it does allow for exceptions. This just basically, I think, just puts it in statute and says, hey, and again, I brought this bill up because we see an increase in sexual abuse with our younger girls, and particularly with our human trafficking, with some of the immigration issues. That's where we're seeing a lot of this. Not just in my corner, but other places in the state that people I've talked to. And so there are exceptions. The courts can choose to use those exceptions or not, but I think in the general past, most of them have not. And so, again, even though, like I say, I do trust the courts, I just think that this bill allows the courts to say, hey, do we want to re-victimize this young 8-year-old or 10-year-old or 12-year-old girl or boy, or do we want to give them another option? And that's really all it does. It doesn't say, you shall, I mean, you may. It's in the court's hands.
Senator Kolb?
Yeah, thank you, Mr. Chairman. And then moving on to this therapeutic dog here on page 5, line 20. I wonder if if it's good to be so prescriptive. I mean, I thought that the judge, respectively, Senator Schuler, judges are the king of the kingdom there, and they do pretty well what they like to do. And if we're prescriptive on something, I don't know, is that, I guess, what's your thought on why it's necessary and why it being prescriptive is a positive thing to do in this instance? Thank you, Mr. Chairman.
Senator Schuler?
Mr. Chairman, if you look on the top of page 5, it just says the court may on its own motion or a motion by a party. So the party could ask for it, but the court doesn't have to do that. So it's permissive. It says may.
Senator Kolb?
Thank you, Mr. Chairman. But they always may do it, right? Having just a discussion about it, the courts have the ability to do it anyway. I mean, that's my reason why I was asking. I'd like, what's it getting us? Because they can do it now. That was, I guess, the question.
Senator Schuler?
Yeah, Mr. Chairman, Senator Kolb, I understand where you're going with this. I think the biggest thing is that I don't know that really courts have really done this much with their young victims. And with the increase, like I said, in sexual assault, sexual abuse, incest, the human trafficking issues, I just think we're seeing more and more child victims. And just wanted to make sure that we had this exception available to the courts. And just let them, to let you folks know that there have been some, situations that have gone to the Supreme Court where they've talked about the confrontational clause, because that seems to be the issue. But there are exceptions in there for child witnesses.
Senator Schuler, if the object is to protect children, why 16 years of age? Is it any less egregious that it was a 15-year-old versus a 17-year-old who was sexually assaulted, or is that just because that's what South Dakota used, or?
Mr. Chairman, yeah, I had some discussions with people about that, because some people, or some states, I think, believe 12 and under, that's really what they consider a child. I think because the situation we're seeing with older, middle school aged and high school freshmen, sophomore types that are getting involved with issues with, the phones, of course, with pornography and sexual abuse stuff. I think that's why we went with 16. And I do believe that that's what South Dakota had also, was 16.
So why not protect the 17-year-old? Why not just make it 18? Or is that a special window where we're not worried about it?
Mr. Chairman, no, I don't believe that's true. It's a cutoff. I could be all right with 15 even, but after coaching and teaching high school kids, 17-year-olds, or I used to call them mini adults, they almost started to act like adults. 16-year-olds quite often, still maybe not so sure. 15-year-olds definitely need to be protected. So yeah, I'm not, gonna die on my sword with 16 and under. So if you have a change there, that'd be great.
Senator Crum?
You just asked one of my questions. Another question is, on page 3, line 11, it says the defendant may waive the right to have the defendant's image televised. Why would that be?
Senator Schuler?
Mr. Chairman, yeah, they may not want their face on there. And I mean, if you were, accused of incest, let's say you were a father or stepfather or whatever, I don't know that you'd want your image on there. So it just gives them an option to waive that right if they so choose.
My only thought on that is, if you were in a courtroom, they don't have a right to put a sack over their head, just a video thing, just a thought. And then my next question, Mr. Chairman, would be on page 5, lines 9 and 10. I'm just not quite sure what this means, to be free of a nuisance and harassing tactic. What is that? I think I have my opinion, but I'm not sure what it is.
Senator Schuler?
Mr. Chairman, Senator Crum, I don't know, I watch a lot of Law and Order. So I see these things happening all the time in courtrooms. I have not been in a lot of courtrooms in Wyoming, but I think it's pretty obvious that if there's a defendant on there and they don't want that person to if they're trying to distract them, make noises, make sounds, to try to distract them from being able to testify, I think that's why that's in there. And Again, maybe I watch too much Law and Order, but they do that, so that's my answer to that.
Thank you. And then my very last question, promise, is on line 10 and 11 of page 6, where it says the child may not testify in a courtroom without the consent of the defendant. And that's after they given the video deal. So the defendant would say the child couldn't do a follow-up testimony or something like that. Is that what this says?
Mr. Chairman, yeah, the prosecutor, if they've got that deposition ahead of time, and the child just say, I can't go through with it, and the videotape has been taken, and the child doesn't get to testify. That's my understanding of that.
Senator Craigo.
Thank you, Mr. Chairman. I was just going to note that that's the existing statute that's already in the green books, and so we're amending that section to take into consideration the new proposed language.
Any other questions for Senator Schuler? All right, thank you. Do you have any agencies wishing to testify on this bill? We didn't get the courts today. All right, general public comment? Come on up. Welcome.
Mr. Chairman, committee, my name is Mike Thompson. I'm the Chief of Police for Evansville. And on top of that, I happen to be the chairman of the Oversight, or DFS Oversight Council, and I sit on the Child Advocacy Board in Casper, Wyoming. This Senate file, this language, was first brought to me by Director Nelson, sit to my right here. And so we were having a meeting and had a really good discussion about why this is important. In the United States, 1 in 5 girls and 1 in 20 boys are victims of child sexual abuse. And over the course of their lifetime, 28% of them, ages 14 through 17, have been sexually victimized. Evidential problems with sexual abuse victims. There's, a successful sexual abuse prosecution generally requires that the child victim testify against the offender. Often in cases of this nature, there's very little, if any, evidence to corroborate the child's account of the offense. Because of the severity nature of the crime itself, most sex offenses, therefore, must be proven by the testimony of the victim corroborated, if the prosecutor is lucky, by medical or laboratory evidence. Thus, the victim's testimony or testimony regarding the victim's statements about the incident is absolutely critical. That's part of the root of this. Cases involving young victims often are complicated further by delay of reporting of the offense. It's not unusual for the child to keep the fact of the incident secret for weeks or even months, sometimes years, before this comes to light. Typically, the offender has threatened the child with physical harm, and threats are taken seriously by these children. Moreover, children often feel ashamed of their involvement and will not immediately tell their parents or other adults what has happened to them. This is especially true if the offender is a member of the child's household. Sometimes there's long periods of time from when they disclosed the actual or the incident to the actual court process due to the defendant avoiding arrest. One example comes out of my jurisdiction where we had 2 kids that were physically abused. I got life flighted to Denver's and Children's Hospital in Denver. The offender went on the run, and it took us over 2 years and had to use the marshal's office to track them down and get them apprehended. So with the time, sometimes the re-victimization is what's important that we need to be considering for these kids. The court process is intimidating for these kids and can experience re-traumatizing them. Witnesses, especially children in criminal cases, can be intimidated by the court process. The factor makes children sexual abuse dramatically different from other criminal cases, that the victims are children. They find it difficult to understand and communicate their experiences. When thrust into the criminal system, the trauma they experience often becomes even more severe. They are fearful for testifying in front of a judge and all the attendees in the courtroom and the actual person that victimized them. Some courts have developed other ways to minimize the trauma that they experienced. In the spirit of fairness is why we're talking about this uniformity. State laws can vary widely, which can leave the courts without a consistent approach. Passing Senate File 100 will help Wyoming have a more uniformed across the state. Codified laws ensure that the child abuse victims can have the same protection under the law within the courts. There's been a national movement, procedural reforms. Many states have introduced procedural reforms to reduce the trauma of the trial for the victim. Codified laws protect the child victims when testifying by reducing trauma and ensuring that they're treated fairly in the legal system. This language is based off of South Dakota, which was testified earlier on. The director, Petro, up there at the South Dakota Advocacy and Prevention, she used guidelines from both North Dakota, Colorado to enact or create these this language. The state where we sit in the 10th Circuit, two of which, Montana and Colorado, were used in this, which we're currently are in that same 10th Circuit. North Dakota and South Dakota are in the 8th Circuit, neither of which the federal courts have ruled in or weighed in on this. Montana, as I was doing some research, passed a similar law back in 2007, and the Montana Supreme Court has yet to weigh in on any of the constitutionality. These kids have the right to have questions asked of them in a developmentally appropriate way. Children should be treated with softer gloves when it comes to testifying. In the end, it is unreasonable for us professionals to continue to ask children to adjust to the world and in the justice system that was not designed for them in mind. As a parent, I witnessed my own daughter, who's sitting here to my left, go through the court process on a civil case in her own testimony experiences, which she can attest to. My department in the last 2 years has had 3 incest cases. The current one that we're investigating and dealing with her was victimized by her dad. And it has a lot of complexity to it. So before I yield to Director Nelson, the only thing I would ask that we also consider adding beyond the sexual side of what we're talking is aggravated assault and battery, which is 62502 AI, and also strangulation under 62509. And with that, I yield for questions and turn it over to Director Nelson.
Any questions for Mr. Thompson? Senator Kolb.
Yeah, thank you, Mr. Chairman. Mr. Thompson, could you comment about page 3? I don't know if you have this in front of you. Page 3, line 11 to 13, as it talks about the defendant may waive the right to have the defendant's image televised in the room in which the child is testifying. I guess your comments about that, if you had any.
Mr. Thompson?
Mr. Chairman, Senator Kolb, what was the line again?
It's page 3, lines 11 through 13.
13. Mr. Chairman, Senator Kolb.
Please.
Senator Schuler actually touched base on that, about a lot of these defendants, especially when it comes to the sexual side, they will potentially waive that right because they don't want to be in front of the media, et cetera. And, you know, in each county in our state, you know, the media tends to be more involved in some than others. And so that's part of why they would waive that right to the defendant's image.
Thank you. All right, thank you, Mr. Thompson. Director Nelson?
Yes. Hi, thank you, Chairman and Senators. My name is Stacy Nelson. I'm the Executive Director of the Children's Advocacy Project in Casper. We provide forensic interview services for primarily Natrona County, and then we also serve about 14 other counties. We also have an office in Sheridan, and all of that I'd like to just address briefly the whole purpose of a child advocacy center. We only have 3 in Wyoming, and the premise of using a child advocacy center model is to minimize trauma to children when they are going through all these different abuse types. And the piece of it is that I feel really lucky that in Casper, we have such a strong team. It's, we work collaboratively with law enforcement, the prosecutors, Department of Family Services, investigators, everyone to use this model and to work as a team so that we can be addressing these issues in the investigation. So a main piece of it is that the kids only have to speak to one person. I mean, theoretically, when the disclosure initially occurs, they will speak to other people. But then it is brought to the child advocacy centers, and we all have trained forensic interviewers who talk to these kids. And ideally, when the whole team can be there, it's the prosecutors, law enforcement investigators, they are watching it from another room. And the reason for that is if questions come up during this interview, it's a very non-leading scenario. I tell people this a lot. I always felt like I was great at talking to kids in a non-leading manner. I worked in the residential crisis group home continuum of care for 22 years before I switched to this role 8 years ago. And, I thought I was great at talking to kids. And then I started working at Children's Advocacy Project, we'll all refer to as CAP throughout this conversation. But I couldn't believe the difference in how well they do have that nailed down as far as non-leading, because we want it to be defensible in court. But the one thing I feel like we've been missing is that piece in court. And I have had conversations with prosecutors, and I think they don't feel like there's enough teeth maybe or backup in the court system to allow for some of these accommodations for kids. And I can tell you, we're small enough in CAP. We're lucky we have therapists that focus on trauma therapy for these kiddos and we always say non-offending family members. And we have a victim advocates and then the forensic interviewers. We are small enough that each of us have different roles. I'm also trained in the role of the victim advocacy piece. And I can tell you when I have that hat on working with these kids, it's incredible what they've gone through. Just throw out some numbers. Last calendar year, we did a total of 262 forensic interviews. 190 of those were for sexual abuse cases. And listening to these girls and boys, it doesn't matter. They all, we do have more female victims than we have male victims. But I can give you an example of one kiddo that I was working with the hat of the victim advocacy role, and her adopted father had been sexually abusing her for years. And she had just been tolerating it, for lack of better terms. And when she finally disclosed something to her mom, and she came in that same afternoon, they called the police. She came in that afternoon, and we worked into the evening to kind of help her out. And we ended up interviewing her sister as well. And I was sitting in our front waiting room with her when she was finished with her forensic interview. And her sister had gone back, and she just took a deep breath, and she said, "I am so glad I finally said something. I just didn't want it to start happening with my sister because she's at the age where it was happening with me." And I can still visualize her just knowing, and not even knowing all the specifics of what was in the interview, because I was out there with her, but just some of the things that she said. But I will tell you, throughout that process, for her, I guess it was a blessing in disguise maybe that this man ended up confessing that same evening to more than what was even disclosed in the interview. So he eventually was sentenced to 50 to 60 years. And so that worked well for her. But throughout that process, our therapists, the advocates, we all worked with them on trying to help with the victim advocacy, or in the victim advocacy role, and doing, working towards having to do a victim impact statement. And just that piece alone was so traumatizing for her that she was not able to do that piece. And we have plenty of other kids that the cases are not pled out. They do have to go to trial. And to watch these kids have to be re-traumatized by having to say some of these things. The majority of the offenders it's not stranger danger anymore. The majority of the offenders that we have that come into CAP are parents or someone they know. And so for them to have to look at them and replay everything that happened to them in front of the offender is just re-traumatizing for them. And it goes against the whole best practice. You know, Senator Schuler and the gentleman that was online, they both have referenced ACEs, and I could go on about that forever. I think there are lots to it. But they've already mentioned that. But just all of that trauma just comes out over and over, and it does impact their lives as an adult. So we are trying the best that we can to minimize that for them and give them some accommodations in court when it is so terrifying, because I can tell you, you know, he mentioned some of the adding the physical abuse and strangulation. We just had a case from out of county last week, and the bruises and the strangulation marks on that little kiddo, it was terrible. And it was a parent that had done it, allegedly. You know, it's not done yet, so I have to say allegedly. But they just have so much trauma. And so if we can do anything to try to help that court system by still allowing the defendant, you know, that, I think it's the Sixth Amendment, but that, you know, understanding they have that right through our Constitution, but still allowing some accommodations for these children that are having to go through it, because they go through a lot. I could tell you stories after stories, but we won't do that.
Questions for Ms. Nelson? Senator Kolb?
Thank you, Mr. Chairman. I would like to hear your opinion, not what anyone had said before. So we go up here on the question about the age, the 16 years of age. It was testified that this goes on for a long time before maybe someone comes forward. So what would be in your opinion, would it be a good thing, a bad thing, or what do you think about saying under 18 years of age? And this would apply to, what's your opinion on that? Thank you, Mr. Chairman.
Ms. Nelson?
Chairman Olson, Senator Kolb, I would have no issue with that, because I know I've worked with 17-year-olds that were terrified as well. If it was determined that it felt like that would not be challenged, you know, you never know with defense attorneys and things what will be challenged, but I think it would be great to give that option. I will say there are kids that are a little older that they find it, once we help them and work with them, it is empowering for them to testify. But giving them that option, I think it would be wonderful to leave it at under 18. I'm not sure what the exact reasoning behind the 16 age was, but if we could change it to under 18, I think it would be great.
Thank you, Ms. Nelson. Any other questions? No? Okay. Welcome.
Mr. Chairman and committee, my name is Brenna Thompson. I'm 18 years of age and I currently reside in Toronto County. I'm here to testify in support Senate File 100 and offer my own experience in court during a civil trial. I feel it's relevant for children who become victims of physical, sexual, and domestic abuse and human trafficking. In 2017, I was a subject of a custody dispute where I was appointed a guardian ad litem and was brought into court for my testimony. Before I even entered the courtroom, I had felt intimidated by a lawyer. With that experience, I had feared seeing her in the courtroom, as well as everybody else that was there. I had anxiety. I was fearful my testimony was not going to be heard as truthful by the judge. This was coupled by having repercussions with family members in and outside the courtroom. This experience I was involved in led me to have emotional trauma, which then I went to counseling for 2.5 years. Counseling provided me a safe environment to express what I was feeling with complete honesty and no fear of repercussions, and ultimately set me up for the road to ultimately heal. Before I was even in the courtroom, my guardian ad litem had brought me into the courtroom and explained to me what was going to happen, what the process was, so that way I was not as scared. He told me where people were going to sit, how I was going to be questioned by other lawyers, including the one I had felt intimidated by. Even after he tried to help me not be so nervous, I still felt overwhelmed, scared, pressured, and intimidated with the anticipation, as well as I was also starting to feel vulnerable and exposed because I was going to have to be in front of a bunch of strangers and say personal things. Prior to being in the courtroom, I had to wait out in the lobby. I was not allowed in the courtroom. This caused me to feel isolated and alone. I was not allowed to see any of the people that made me feel safe or secure of myself. I was not ultimately called into the courtroom. Instead, I was called into the judge's chambers, where I had learned my guardian ad litem or other counsel was not allowed to be present. Upon entering chambers, my fears and anxieties, intimidation compounded inside of me. With all of these emotions, I froze and was unable to give my testimony as I intended. Had my guardian ad litem was present, I feel like I could give my intended testimony. My guardian ad litem, his job was to help my voice be heard, and he knew my true words. He was a familiar face that I trusted and who had actively tried to make this experience less intimidating as possible. Obviously, I'm a cop's kid. Over the years, I have often heard my dad talk about some of the cases he has been called to investigate that involve kids who have been physically or sexually assaulted. After my own experience in court, I have thought about how it would be worse for them, especially because not only do they have to feel vulnerable and exposed with much more strange faces in the room, but also they have to face their abuser, should their case go up to court. During my middle school and high school, I interacted with classmates, several of which I became friends with. One in particular, I learned they had been sexually abused by their brother. She was ultimately scared and shared some of the same anxieties that I had, and feared that her family was going to be against her if she tested against her brother in the court. I had other friends and classmates that had similar experiences. I have come to learn that kids who have been through physical and sexual abuse may not heal for years, to include their entire life. Even though my court interaction was civil and looking back on all that I went through emotionally, I believe in enacting this law will help protect children who are victim of criminal acts. The court portions is one of the first steps to be able to move forward and heal. Children being able to testify outside of the presence of the defendant will help them be more open and willing to offer their testimony. I hope by enacting this law, they will not feel as vulnerable or have to feel exposed like I did or be re-victimized. Enacting this law will set a standard across the state for all children to be afforded the same protections no matter what jurisdiction they reside in. With that, Mr. Chairman, I stand for any question, fully support Senate File 100.
Thank you, Ms. Thompson. We appreciate you sharing your story with us. Very helpful. Thank you. Other public testimony on this bill? We are trying to move forward, so try not to be repetitive, be succinct.
Mr. Chairman, members of the committee, thank you. I will be very brief. My name is Lynn Story-Heiler. I'm the director of Safe Harbor at Children's Justice Center. We are a child advocacy center in Cheyenne, Wyoming, and I am the on-site dedicated forensic interviewer there. So I've been forensically interviewing children for over 20 plus years. I don't want to be repetitive what was already been said. It's been beautifully said. I would just like to share with you that the field has really moved to when we're getting the information from the child, we, through research and best practices, we do it in a very prescribed manner. We control the room where the child goes to tell their story. It's just the interviewer and the child in that room. It is video recorded, and the child does know that they're being video recorded. So this new law would not be something that the child maybe wouldn't already be familiar with, a videotape deposition or a testimony. In that forensic interview room, we try to control the language that we use. We try to, we're only asking non-leading questions, and only the child and the interviewer is in that room. We want to make it developmentally appropriate, sensitive, and we want to make the child comfortable. I think this law just adds another level of that protection for children and their testimony. And lastly, I just want to share with you, because there are cases in my 20 plus years that haunt me. And I'd like to share their story just briefly and give them voice in this context. There's 3 cases that come to my mind. First one is a young lady. She was sexually abused by her stepfather, and these are all been adjudicated, so I can talk about them. She was sexually abused by her stepfather. Her mother set up an arrangement between her and her stepfather, and then mother actually joined in at one point in time. This young lady was 14 at the time. She testified. She bravely testified. Her perpetrators were put away. She is no longer with us. She ultimately committed suicide. Now, it wasn't probably because of her testimony, but it's because of the whole trauma. And if we, as a society, can do anything to lessen that trauma, I think it behooves us. I'll tell you just another story. I have many more to go, but this was a recent one. I was testifying, and this was more of it was a hearing prior to even the court process. But the young lady went into court. It was against her father. She went into the courtroom. I was waiting outside because I was going to testify and had to wait outside. She comes out of testifying against her father. She walks through the doors and she collapses on the floor right outside the doors. That's how traumatic it was for her. A team of people rallied around her and she had the support outside of the courtroom, but she did not have that support inside the courtroom. So I add my voice to those victims. We as a body need to make sure that we are looking at them and taking care of them in the best manner that we can. And so I would ask you to support this. I think that this is good legislation, and I think a lot of other states already do this as well, and we would just be adding to the protection of children. Thank you.
Given your story about the young lady not having support in the courtroom, do you think that should be a requirement in this statute, that we should direct that the court, when it's requested always, as opposed to having a may option to provide that this has what's called a person who would contribute to the well-being of the child present?
I do. I think there's lots of people that could provide that role. It could be a victim advocate that they've built a relationship. It could be a therapist that they've built a relationship. It could be a grandmother. A lot of times that person can be their sight, and you can say, look at me, look at me. Don't look at the defendant, but look at me. So yes, I do think that is a good adding to this. Also, I would say it should be 18 and under, because my 14-year-old who's no longer with us, she was 14 at the time it happened. By the time it went to court, she was 16. And I think we should include under 18.
Perfect, thank you. Sir, go ahead.
Mr. Chairman, members of the committee, my name is Clark Fairbanks. I'm the director of Wyoming Youth Service Association, which is a youth service, nonprofit youth service agencies across Wyoming. And in my prior role, I have 35 years, prior director of youth emergency services and prior superintendent of the Wyoming Girls School. My perspective in this is also as a child protection team member. And I'm speaking on and in favor of this bill, and just really encourage your consideration. This would allow child victims who've been abused, often threatened by their abuser, to remain silent. A threat that as an adult would be emotionally terrifying, and as a child, even more terrifying, and often prevents their ability to speak to the traumas that have occurred. This bill, I believe, would allow them to find it less traumatizing and less negative impact from their testimony. So I just wanted to urge your consideration of allowing this as an option. And I would stand for any questions that you might have.
Any questions for Mr. Fairbanks? All right, thank you. Okay, with that, I will close public testimony. Committee, what is your pleasure?
Move the bill.
It's moved by Senator Kolb. Amendments to this bill. Start with page 2. Any amendments to page 2? Senator Kolb.
Yeah, thank you, Mr. Chairman. On page 2, line 4, strike 16, the word and the numerical number, and insert 18.
Okay.
And also, you want to do these one at a time? There's a similar one.
One at a time.
Okay.
But that should be made on page 4 as well. if that's
Correct.
what you-
Page, yeah, page 4, line 23, same amendment, strike 16, insert 18.
Yep. That's one amendment. Okay, any discussion on this amendment? Senator Crago?
Thank you, Mr. Chairman. So I am supportive of the idea. I'm just a little bit curious, and we haven't really got into the details on what the constitutional law is on this and why other states aren't using 18, because it's the rational number. There might be some case law out there. So I guess I'd just caution us to wade into this slowly. I mean, I'm supportive of the idea, but we may need to backtrack when I'll dig into it between now and we bring this on the floor and make sure, because I don't want to sacrifice good for perfect. And so just making that comment that while I'm supportive, I think we better figure out why other states haven't gone to 18 instead of 16. And I also would note on our videotape depositions, that age is 12. And so we're gonna have two different ages within the statutes that at some point, we're probably gonna have to fix that too.
Okay, we'll move to 18 and you'll do all the constitutional research.
You're welcome, Mr. Chairman.
Okay, any other discussion? All those in favor signify by saying aye.
Aye.
Any opposed? Okay, what about on page 2, is there any interest in adding the other crimes that were mentioned to the list? I don't know if that, Senator Craigo, if you have an opinion.
I don't have an opinion.
Okay.
I'm happy to add them if that's what the, if that's what the committee wants to do. But at this point, that's also one that we could do later and maybe do a little bit more research and just figure out, again, where
That's what
we
I was
are
thinking.
with in line with Constitution.
Okay. Senator Kolb?
Yeah, Mr. Chairman, I'm good with where it's at currently. I think we can improve it on the floor and for the readings to come. But I think, as was stated earlier, not to damage something for the pursuit of perfect. Thank you.
Okay, how about page 3? You asked a lot of questions, Senator Kolb, about page 3. How do you really feel about it? Tell us how you really feel.
Oh, well, Mr. Chairman, it's probably pretty clear. I just wondered if that's really something that should be in here or not. And, I probably rely on the attorneys here to tell me what you believe, if this is a good thing or a bad thing. I was trying to get edification for my own benefit and to the people listening about why it's in here. That's why I was asking the questions, Mr. Chairman.
Senator Craigo?
Thank you, Mr. Chairman. I actually don't have a problem leaving that language in, and I actually think we need to leave it in. It's for the benefit of the victim, right? So what we're talking about here is when the victim is in that room over here, the jury's sitting, and the rest of the courtroom is sitting out here, and the defendant is sitting out here because the judge has made the finding that the defendant can't be in the same room as the victim. The defendant may say, look, I don't want to inflict any more pain on the potential victim than has already been done. I'll waive my right to have my face on the camera in that room, and that's what that's applying to.
It benefits the victim, which is why it's confusing that it's the only option to waive it is in the right of the defendant. I mean, in your scenario, it would make more sense that the victim have a right to say, I don't want to see his face on the screen while I'm testifying. That's not in here.
Mr. Chairman, I think what the bill is attempting to do is find the right balance, right? We're trying to find the right balance so that our law isn't found unconstitutional right off the bat. And so, again, I think the good sponsor brought us language from another state that has proven to withstand, even though it hasn't been litigated, it hasn't, that's also a sign that it hasn't been litigated. And so I guess I'd prefer we leave it the same and keep that balance where it is.
Okay. Any amendments to page 4? We already did one on page 4. Page 5.
Mr. Chairman,
Senator Crum?
line 1, it states in there after the paragraph, the court may on its own motion. I'm wondering if we should say the court shall, upon a motion by a party, provide the following. So we would put in shall instead of may and then strike may on its own motion or.
Okay, is that your motion?
That's a motion.
It's okay. Any discussion on that motion? I think Senator Kolb would like to.
Well, yeah, Mr. Chairman, I heard it said in the past that us telling the court to do something like this might not be, might not get us anywhere. So that's my concern about that, Mr. Chairman.
Senator Craigo?
Yeah, Mr. Chairman, I also am going to oppose the language of shall versus may. I don't want to take the discretion away from the court. Again,
The court could already do it. If there was a motion filed for any one of these, the court could order. There's nothing that prevents the court from allowing any one of these now.
that's right, but we're now saying they have to. And I guess that's, and actually, I'm not sure they can do any of these without statutory permission. I mean, I think that's what we're trying to get at. I guess I just don't know if I want to, I'm not in a place where I can substitute shall for the may. And why are we requiring them, and which of them? Is it just one or
The on-
any, or,
the
I
only
mean,
one-
what's your reasoning, Mr. Chairman?
Yeah, the only one that really stands out to me is having the emotional support person there. And although the one of the case examples we were given was I believe it was a custody case, and the guardian ad litem was excluded from the judge's chambers, to me, that's kind of extreme. I think your attorney should be present when you're being questioned, even if you're a minor. So that, I know that's not necessarily addressed by that scenario, but if a child had a guardian ad litem, I think the guardian ad litem should always be present when the child is being questioned. That's a basic attorney 101. But I can also see the benefit of requiring the emotional support person to be present. Some of these others I'm not as wild about, like therapeutic dog.
Yeah, Mr. Chairman.
But I'm not, I don't do criminal defense work, so they have a victim advocate, I assume, but there's not a scenario where they have a guardian ad litem, right? Or are there some scenarios where they would have a guardian ad litem?
I think there are potential places where that could happen.
So I would think, and this language isn't perfect, in my mind, it would say a guardian ad litem, a victim advocate, or any person who provides emotional support to the child shall be present. But if you also want to leave it up to the court, I understand your reasoning behind that. I don't think allowing an emotional support person is tying the hands of the court, because I can't think of a scenario where the court really should, on good faith basis, reasonably deny that request. But apparently they do, because they apparently don't allow guardian ad litems into the room.
I don't know how widespread that particular circumstance is, Mr. Chairman. I mean, if that was happening every day, I guess I'd be more likely to agree with you. I just don't know the circumstances, or, like I said, how often that's happening. I'm just looking at I just know what the word shall sometimes turns into. And if you're on the other side of that, and we're trying to decide which of these the judge has to do, and we have this long list, and I can think of a lot of instances where that could get abused from the other side.
So you think the courts didn't show up today because the bill said may and they weren't worried about it?
Yeah.
So if we put shall, they'll
I think,
show up?
I bet if you put in the word shall, they will show up. Yes,
Okay.
Mr. Chairman.
All right. Any other amendments to this bill?
Mr. Chairman,
Senator Kolb?
just a general discussion first, but on page 5, under 5, to have your therapeutic dog there, I mean, I guess, and I'm not an attorney, nor do I have a certificate in my wallet that says such a thing, but I have heard that if you go into a courtroom with like shackles, if you're a person being accused of something, you look guilty. It would seem, I could see maybe out of sight the support dog, but to have it visible, wouldn't that be problematic in an appeal for someone saying that the person looked more sympathetic or not? That's my question.
Senator Craigo?
Not necessarily a comment on the dog issue, Mr. Chairman. I just was going to mention that, again, before this, I'd have dug into this a little bit, right? And there is a Supreme Court case, U.S. Supreme Court case on this particular issue. And the Supreme Court's pretty clear that it requires a balancing, and it requires a factual determination every time the issue comes up. And so that's, as far as the dog issue, if we leave the language with may, we give the courts the discretion to decide, is it more harmful or not, right? Are we actually impeding the defendant's rights more than necessary with a dog? I agree with you on the guardian ad litem and having a representative. That one's more important than the rest of them on there to me. But if we leave it at may, I think we have a better chance of the law being constitutional and withstanding in the long term, because then it does require the court to make a finding before any of this can happen, and it satisfies the Supreme Court's direction of a balancing.
Senator Kolb?
Further question, but the court has the ability to allow that if they so choose to anyway. They could always allow a support dog if you you make your case about it's necessary, or wouldn't they unless there's a may in there? That's
I-
the question.
Senator Craig said he doubts that they would have statutory authority to do these, or have authority to do these things without a statute. I disagree. I can't, I think if the motion was made for a therapeutic dog and the court really agreed with that, I think the court could allow it, because there's not a statute saying they can't do that.
Mr. Chairman,
Yes, Senator
I
Craig.
actually, and I may have misspoke. I'm not saying they don't have the authority. They might, and they probably do. They're just not likely to use it without some sort of statutory backup.
That's probably true.
That's how I'm seeing this, is we're giving them the authority to do some of these things that they can then lean on in the court and say, hey, this legislature found it appropriate for us to do these things, so I'm gonna make this finding and make this decision. Could they do it now? They run their courtrooms, they have the ability to do it. I just don't think they're likely to do it because they're worried about what will, the issues they would create for appeal on the backside.
Are we, in this section, Senator Crago, are we running a risk of creating a list here, though? That the court will feel that we felt it was important and necessary to make this list, and these are the only exceptions? Because I think, I don't know enough about this state and why they put this in their statute.
I think that's a valid concern, Mr. Chairman. I mean, that's more valid than probably the rest of the stuff we've been talking about, to be honest. But I actually think that's valid.
Okay, so that's a little bit different than shall. That's more of a, do we remove the list or not question. Are we on Senator Crumb's motion still?
Yes.
All right. Any other discussion on this motion? Senator Crum?
I'm going to withdraw the motion based upon what I heard about from the legal beagles there.
Okay.
And we just need to research it more. But I do think we need to protect the child.
Can we, maybe the way we can fix this list is at the top of page 5, line 2, we say, provide any of the following, provide any of the following accommodations, but make it including but not limited to. So may provide, including but not limited to any of the following accommodations, however that should be worded. And then the court could find other accommodations reasonably necessary under the circumstances, because we can't think of every scenario.
Included but not limited to.
So where would we insert that? Let's see. Okay, so the motion is to include the language on lines 2 and 3, including but not limited to, where LSO feels that it fits best. Because I can't do it right now.
So suggestion, Mr. Chairman?
Unless you have one.
Yeah, I think I can make it work. So I think you could provide reasonable accommodations after the word provide, including but not limited to any of the following.
There you go.
Something like that. LSO can make that one work. No.
It was perfect.
Provide, after the word provide, it'd be reasonable accommodations, including but not limited to.
And strike any of the, and then following accommodations to the child on line 3.
Yeah, and it probably should say provide reasonable accommodations
To
to
the
the
child.
child, including but not limited to the following, :
Sounds good. Everybody in favor of that motion, say aye.
Aye.
Any opposed? All right, and that's the end of the bill unless somebody has something on page 6. Any general discussion? No discussion. Pierre, will you do a roll call vote on Senate File 100?
Senator Crago,
Aye.
Senator Crum,
Aye.
Senator Hicks,
Excused.
Senator Kolb,
Aye.
Mr. Chairman.
Aye.
Mr. Chairman, you have 4 ayes and 1 excused.
All right, there's another one for you, Senator Schuler. Yep. All right, and we did not get to Senate File 180, which we will notice for our next meeting, which will be tomorrow at noon. So if you were here for that bill, we'll see you tomorrow. Thank you, and we are adjourned.